Good afternoon and welcome to the House Criminal Justice Committee for Wednesday, March the 30th. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Halsey, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio.
Here.
Mr. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, before we get started, do we have any personal orders? Okay, seeing none, I do have a couple of announcements, or really one announcement before we get started. Item number 8, which is House Bill 2211 by Chairman Russell, will be rolled 1 week. And also item number 9, which is House Bill 2212, also by Chairman Russell, rolled 1 week. That brings us back to item number 1, House Bill 2677 by Vice Chairman Leatherwood. Vice Chairman Leatherwood is in the room, and he's recognized. Sir, you have a motion and a second.
Thank you, Mr. Chairman, and there is an amendment.
Yes, sir. I see amendment coded 15810. Is that the amendment you wish to move forward? We have a motion and a second. And members, it looks like that amendment makes the bill. Is that correct, Mr. Sponsor?
That is correct.
So without objection, I'd like to vote to go ahead and get this on the bill. All those in favor of attaching amendment coded 15810 onto House Bill 2677, please signify by saying aye. Those opposed, you adopt. On the bill as amended, sir.
Thank you very much, Chairman and Committee. This bill creates an offense for an employer to influence or attempt to influence by means of coercion a public servant employee to vote or not to vote in a particular manner, or to resign as a public servant, or to unnecessarily recuse themselves from a public body. And that's what the bill does, and take any questions.
Members, you've heard the explanation from the sponsor. Do we have any questions for him about the bill? The question's been called. All those in favor of sending House Bill 2677 as amended to Finance, please signify by saying aye. Those opposed? Sir, you head to Finance.
Thank you.
Thank you, sir. That brings us to item number 2, House Bill 1878 by Chairman Littleton. Ma'am, you have a motion and a second. I see no amendment. You are recognized.
Of sex offender registration fees by the registering agent to include the investigation of sexual offenses and the purchase of specialized equipment for use in the investigation of sexual offenses.
Question's been called. Without objection, we're ready to vote. All those in favor of sending House Bill 1878 to Calendar and Rules, please signify by saying aye. Those opposed? Ma'am, you head to Calendar and Rules.
Thank you.
Thank you. That brings us to item number 3, also by Chairman Littleton, House Bill 2234. Motion. Second. Ma'am, you have a motion and a second. You're probably recognized.
Thank you, Mr. Chairman. This removes a conviction of prostitution as a requirement for a person to be eligible for expunction of multiple nonviolent convictions for offenses that resulted from the person's status as a victim of human trafficking. And I do have a couple of women that would like to testify, please.
Yes, ma'am. I see I have Alyssa Bernard and Regina Mullins.
That's correct.
Is that correct? Okay, those two, and they are here. So, members, without objection, we are going to go out of session to hear from these witnesses. We're out of session. Ladies, if you'd like to come forward, you can stand at the podium or you can sit in the chairs wherever you're most comfortable. I'll ask that you speak one at a time, and what you'll do is just turn your microphone on, introduce yourself for the record, and then share with this committee whatever you'd like, and you'll have 3 minutes. But after that, there will be unlimited time for question and answers if members have questions for you. So you're recognized.
Can I ask a question?
Oh, sure.
Is that 3 minutes each or 3 minutes total?
3 minutes for each of you.
Thank you. All right. So my name's Elisa Bernard. I'm the Director of Public Policy and Advocacy for Thistle Farms. You'll have to excuse me, I have a little laryngitis today. So thank you to the chair and all members of the committee. I, again, am the Director of Public Policy and Advocacy for Thistle Farms. We're a nonprofit based here in Nashville. And for the past 25 years, we've had the honor of serving women survivors of the sex trade, addiction, and incarceration. We only serve adult survivors of the sex trade, yet many do not qualify for the current human trafficking specific expungement law. The problem being is that the law hinges eligibility for expungement on the presence of a prostitution charge. I spoke with one woman today who did not qualify for expungement, even though she was a trafficking survivor from Nashville. According to TBI data, arrests for prostitution are down 65% over the past 8 years, And we are seeing this shift at a national level. We're seeing this across states. Additionally, survivors of trafficking who successfully complete a diversion program have their prostitution charges cleared, and clearing that prostitution charge also eliminates their eligibility for trafficking-specific expunction. Essentially, the law is really only working for a very small minority of the population that we serve and the population that many of us care very, very much about. And at Thistle Farms, we hear stories every day of how trafficking pushes people to commit a wide range of crimes. A 2016 report by the National Survivor Network surveyed 130 survivors of human trafficking from 32 states, including Tennessee. 90.8% of the survivors surveyed expressed that they had been arrested. 76.3% said they were arrested 3 or more times, and only 25% had even attempted to get their records cleared. At Thistle Farms and other anti-trafficking nonprofits I've worked with, I've seen survivors whose pimps push them to sell drugs on top of prostitution, and I've heard from prostituted people whose traffickers' quotas were so high they would choose to commit robbery rather than have sex with upwards of 20 strangers a day. Yes, they broke the law, but what kind of choice is that when you have the choice of grabbing a wallet off of a nightstand or saying with your 20th John? HB 2234 would give survivors like me the opportunity to move past their exploitation. To them, expungement means not having to pay the price for something that was done to you or something that you were forced to do. And a criminal record is a very heavy price to pay for being exploited. So we urge you to listen to survivors like the women we serve, myself, and Regina, who will speak next, to support House Bill 2234. I appreciate your time.
Thank you very much, ma'am.
Hello, I'm Regina Mullins, and I have a question right quick.
Yes, ma'am.
Can I just be me?
We would love for you to.
Thank you.
Yeah.
Okay. I'm Regina Mullins, and I'm a 1999 graduate of Thistle Farms. I'm also a survivor of prostitution and sex trafficking. And in 97, I came out of prison. I came out of prison to what I thought was going to be a community that welcomed me back into it, because that's what I was told. You know, I went into this program, and I felt the welcome. I felt the love. I felt everything that I needed to. Upon trying to obtain a job, I went to the Career Center to learn about new resumes. I went and learned about interviewing styles. I went to apply for jobs and did the interviews. And time after time after time, I was turned away because of my record. That didn't stop me. I was like, I've paid my penalty, I've paid my dues, I've done my time. I'm still going to try because I have 3 sons that I was trying to get back, and I wanted to show that I could provide for them and that I'd never have to look back to that lifestyle ever again, right? So I continued time after time after time to go and interview for jobs that I qualified for. But because of my record, I couldn't get those jobs. I couldn't get a job. Now, there were many evenings that I would cry to my founder and be like, this is just a self-esteem buster. You know, it's like people, it's like my community that welcomed me out wants me to go back to that lifestyle. I'm not going back, but I don't know what to do. Thank God for Thistle Farms, you know, where we started to learn how to create an income, a legal income. And so I'm coming to ask y'all to invite you really. Help me. Help the community that we're in. We're Nashville strong, yeah, I'm with that, you know. Help me, help women like me to be able to get those records expunged, you know, so that we can move forward, provide and take care of ourselves and our children. Thank you for your time.
Thank you very much, ma'am. Members, do you have any questions for either one of these witnesses? Leader Lamberth, you're recognized.
Ma'am, I just want to say thank you for your testimony. I personally, we don't know each other, but I was listening there and know a bit about the program, especially there with Thistle Farms and everything. And I just want to say that we're very proud of you. I mean, you walked a road that none of the rest of us can truly understand. And every day when you get up, you're winning a battle. And so I just wanted to say congratulations on your journey, and that we're very proud of you, ma'am. So I just want to say that.
Thank you, Leader Lamberth, and I would second that. My wife had the opportunity to tour Thistle Farms several years ago. Was very familiar and came home just talking about it just amazingly, and we've kind of followed Thistle Farms and its work ever since. So thank you for being here, and thank you for continuing the work that you do. Absolutely. All right, members, we'll go back. Chairman Holsey, you recognize? For the sponsor, right? Oh, back in session. Okay. Representative Hardaway, for the sponsor or?
For our guests,
okay,
sir.
You're recognized, sir.
And Ms. Mullins, I admire your courage and your eloquence in how you present. That's admirable. Let me ask you about your experiences in coming out. Were the reentry programs adequate? Did the government lend a hand?
And
was it inadequate or adequate?
It was adequate. It was adequate. It was more than adequate. That's how I'm allowed to stand here today. Mm-hmm. It was more than adequate. And it was adequate to the fact that we had you and part of the city supporting us and Becca in bringing us back out into this community. Yeah. And so what wasn't adequate was trying to get a job to support ourselves and feeling like I've got to go back and be sex trafficked or back to prostitution or back to drug addiction. What were we going to do?
And I think one of the problems that we always have with criminal justice is being able to empathize, put ourselves in the spot, in the place of the victim. You've done an excellent job of presenting on that. I especially paid attention to your quote, self-esteem buster.
Yes.
Your dignity, your self-esteem, your self-worth, your value.
I wanted to be a mom again. I wanted to be a mother again. I wanted to show the courts back then that my mother and my parents had custody of my children. I wanted a chance to be a mother again. I wanted to show not just my mom and dad, not just y'all, but I wanted my sons to know that I could provide for them. I could take care of them. I made, y'all excuse me, I made a deal with God. If you give me a chance to be a mom again, I'm going to be the best mom I can be till you call me home, And so, in part, in doing that, I had to have a way to take care of us. But every time somebody looked at me, I was looking the part or whatever, but when they looked at my record, all of that went out the window, and I had some education behind me, but all of that went out the window. So I wasn't able to get the jobs.
Well,
Representative Hardaway.
Thank you. And I'm going to repeat how much I admire your courage, your eloquence in your presentation, and I'm certainly supporting the bill along with, I would dare say, all of my colleagues to help you to help yourself. Okay? To help everyone. Yes, ma'am. Okay. Thank you very much. Thank you, Mr. Chairman.
Thank you, Representative Hardaway. Members will go back into session. Now we're back on item number 3. Chairman Littleton, you're recognized.
Thank you, Mr. Chairman, and I suggest that everyone visit Thistle Farm Cafe. That helps supports these ladies because they work and they do get to work there and try to help themselves get back on track and find better jobs.
And on my list, I have Chairman Holsey, you're recognized.
Thank you, Mr. Chairman, and thank you for the bill. I just wanted to make sure the removal of the word as a condition of expunction, is that because there's other forms of human trafficking that goes on that would not require that word, or is it because in a lot of cases human sex traffickers are actually not arrested for prostitution, even though it's apparent or it's there. They have just never been charged with it.
Chairman Littleton.
I think the problem is that they've been trafficked and they are charged with prostitution. We are moving.
We are, and I think you're right. What's happening is because we've made a change in the law, folks who are being trafficked, thankfully, are no longer getting that prostitution charge. But the code still read that in order to be eligible for expunction, prostitution charge had to be present. And so thankfully, because this body saw fit to change that, these folks are not getting a prostitution charge when we can prove that they've been trafficked. And so they're not eligible for the expunction because this section of code wasn't updated. Yes, sir. Representative Griffey, you recognized.
Thank you, Mr. Chairman. Thank you, Chair Lady Littleton. I don't mean to make light of the legislation we're considering today, but is the Thistle Farms Cafe, is that the one on Charlotte? Okay. I went out there this morning. I was going to eat breakfast. I really wanted French toast. They didn't have any French toast. You need to get them as a French toast in the menu.
Chairman Littleton.
Thank you.
Don't hold that against my bill. I couldn't help it either.
Leader Lamberth, you recognize.
Thank you, Mr. Chairman. And Chairman to the bill, I just want to publicly state a conversation we've been having privately that is on kind of this bill and any other expungement bill that we might address. And this is something probably for next year, but it's something that would have gone well on this bill, but it'll cost a lot of money. So there is no central database for folks to be able to apply to get an expungement. There's no staff that actually helps folks be able to navigate the expungement process. Our clerks throughout the state do a really good job of trying to do that. I mean, it's a one-page form for most folks, but like the young lady that testified, I mean, many folks wind up with convictions in multiple different counties that may be eligible for expungement. Some of those have been dismissed. Some of those are, divertible. I mean, there's lots of different things, but there's not like a central place where they can go to a website and say, I'd like somebody to look up my entire criminal history and expunge anything that's expungible. If we had that, I genuinely feel like ladies like this and others that will be helped by your bill, it would just make it so much easier. So I just put that out there for food for thought to chew on for probably for next year. It's just something that's kind of been missing in the process because even with this bill, I mean, folks are going to have to go to each clerk's office and apply. And that's doable. Takes a lot of work. It's worth it. I mean, it's something that folks should take individual responsibility of. But if we just had something centralized, it'd be good. We don't have a centralized court system. It's all separated out. So I just want to mention that and just something to think about maybe for next year.
Chairman Littleton.
It seems our list keep growing for next year, right? Thank you.
Representative Griffey, you're recognized.
Thank you very much, Mr. Chairman, and to echo my colleagues, Leader Lambert's sentiments, I'm fully in favor of that. I would ask the body and the General Assembly to consider that because expungement is forever, and we do judge people based upon their past history. I would advocate a system where we have a system that prior convictions can be sealed by a judge, however many number he feels the judge is appropriate, and then there's also a process of expungement that the judge feels that the conviction should be totally expunged off a person's record. This would, and the burden for sealing somebody's record for employment purposes of somebody going to be much lower bar than expungement, because what we want to try to do, the whole purpose of criminal justice is to try to get people not to violate the law and get back in the workforce and be productive members of the community. And I think a two-tier system like that might actually benefit that. So I'll leave that to my fellow colleagues and members for maybe for next year's for further thought. Thank you.
Thank you, Representative Griffey. And I do. You're obviously you do this for a living, and you're not wrong. But I want to. This would not be forever. So if you reoffend it, of course, it could be reopened, and that could be used to enhance your sentence later on. But we're obviously the folks that we're trying to help here are hopefully not in that situation. But just to clarify, but your point is well made. Chairman Littleton, you recognized.
Thank you, Mr. Chairman. I do want to thank these ladies for coming out, to have the strength and the courage to come out and speak for the other people.
Yes, thank you very much. Members, if there's no other questions, we're ready to vote. All those in favor of sending House Bill 2234 to calendar and rules, please signify by saying aye. Aye. Those opposed? You head to calendar and rules.
Thank you very much.
Thank
Chairman
you.
and committee.
That brings us to item number 4, House Bill 2789 by Representative Powell. Motion. Sir, you have a motion and a second. I also see an amendment coded 14165. Do you wish to move forward with that? We have a motion and a second on amendment coded 14165.
Yes, that's right.
All right, and it looks like the amendment rewrites the bill, so members, I'd like to go ahead and get this amendment on the bill. All those in favor of attaching amendment coded 14165 to House Bill 2789, please signify by saying aye. Aye. Those opposed, you adopt. We're on the bill as amended, sir.
Thank you, Chairman. So in 2016, we enacted the unlawful exposure statute, commonly known as revenge porn statutes or non-consensual pornography statutes, which criminalizes the distribution of nude images of an identifiable person that the depicted individual did not consent to being distributed. By doing so, Tennessee joined 46 states and the District of Columbia. Currently, a person violates this law if the person distributes an image of the impotent part or parts of another identifiable person, and the image was taken or recorded under certain circumstances where the parties agreed or understood that the image would remain private and the person depicted in the image suffers emotional distress. However, since the inception, there have been some prosecutorial problems have emerged where certain images should qualify under the spirit of the law but do not meet the letter of the law. Specifically, here in Davidson County, which is where I represent, there was a case where a victim was subjected to non-consensual pornography when a former partner distributed a picture of one of her private parts to her family in the workplace. The judge who initially ruled on the merits of the case expressed doubt the picture met the qualifications of a identifiable person, as the judge believed the party had to be identifiable within the four corners of the photograph. Thus, the picture of an isolated body part was believed by the prosecutor handling the matter to represent a losing case because the victim's face did not appear as an identifiable factor. In another case, the victim was identifiable in the distributed photo, was engaged in the sexual act, however, she was fully covered. A covered but unidentifiable victim engaged in sexual activity does not meet the statutory language where his or her intimate parts are not strictly visible. So this bill simply cleans up the language so it's clear that such instances are covered under the law by adding distributing an image of an identifiable person engaged in sexually explicit conduct to the definition of the offense of unlawful exposure, and adding a definition for identifiable person, and expanding the current language to include sexually explicit conduct as defined currently under code. With that, happy to answer any questions.
Thank you, sir, for that explanation. I do have Chairman Doggett on the list first. You recognized?
Thank you, Mr. Chairman and sponsor, for bringing this legislation. You talk about identifying characteristics. Would you have to be able to see a person's face in the photograph for it to fall under that, or how could that be done there?
Representative Powell.
You would not. So the person would have to obviously show that they were identifiable, state that it was them, and then ultimately, if this were, say, to go to a jury trial, that would be part of that process.
Chairman Doggett.
Very good. Thank you very much.
Thank you. Leader Lamberth, you recognized?
Thank you, Mr. Chairman. So when former Representative Turner was here, I actually was a co-sponsor of this bill. He and I worked on this issue together for a couple of years before we finally got it into the law, and I actually saw him out on the sidewalk the other day, so it's good to see him. But when we were working on this, I mean, one of the cases that had come up way back when I used to be an assistant district attorney, there was a young man and a young woman that were married, and the gentleman worked at a specific place, that had quite a few employees, and his spouse, his wife, sent him some pictures that were of her without clothing. They were very, private in nature. A coworker, he had set his phone down. Apparently, they found all this out later. Saw his phone go off or whatever. I guess it was a text picture or something. Sees the phone go off, picks it up, immediately realizes these are pictures intended for the husband, and then sends those pictures to himself, this third party, okay? Mm-hmm. Stole something very intimate and private between a husband and wife in that circumstance. Months go by, and she gets a call from a friend that said, hey, I had no idea you had images out on a website, and was embarrassed to then find out that this lady didn't know either. And so she said, yeah, your picture's on this website. It's pictures of you without your clothing. It's very obviously you. And they wound up at my office, the husband and the wife. They figured out by, I guess, looking at his phone that what had happened, okay, that this third party had literally stolen these images. These folks were high school sweethearts. No one had ever seen this young lady naked as an adult. I mean, like, no one besides her husband. And she was mortified, and there was not a thing I could do. So I tell that story in that very difficult circumstance because I explained that they could try to sue the guy, they could do other things, but unfortunately that was not illegal, okay? So the original bill that we put out there, we tried to craft in a way that would. This one seems to merely, and it limits it to, sexually explicit conduct. So that's my question. Is it your intention that if someone takes pictures of that nature, even though there might not be anybody else in the picture but just them, that would still be illegal?
So you're saying if it's just if you can restate the question, because I'll listen to your entire scenario, but I guess the intent, and let me just say the intent of this, is for two things. One, if there is a sexual act and the person is clothed, so that's the first issue. Obviously it's a sexual act, but clothed. The other is if it's a body part that is sexual in nature, that even, like, for example, you could have a situation where somebody might even have an identifiable tattoo, and that would be very clear. But again, if it was more broad, then that would also be included in this. So that's, I don't know if that answers your question or not. I know you gave a lengthy scenario there. I mean, something, I think is an issue that you brought up, but that's the intent of this bill.
Good.
Leader Lamberth, you recognize.
Chairman, if we can go to legal on that, just to make sure that sexually explicit conduct, I think that's the wording used here, would catch that type of situation, because I wanted to make sure that you were intending to catch that kind of situation. Again, that's where we started years and years and years ago, because while that might not be the wisest course of action for two people to exchange photographs that are private in nature without their clothing on, but my understanding in the world we live in, that happens, on a somewhat regular basis with folks out there. And if it's intended to be a private transmission of this information, those two young folks that were in my office, it will stay with me forever, of just how mortified and quite frankly, harmed they were. I mean, it really, really, really just hurt both of them, not physically, but it really, I mean, both the husband and wife are in tears in my office, and over some jerk that, stole something and decided to put it out on the internet. I didn't tell the entire story, but the reason he did this is he had a falling out with the husband or whatever. They got into some argument at work. And so then it is literally what you have described as revenge porn. These people had a falling out, and so he thought, fine, I'll put these pictures of your wife out there. I mean, he did it out of absolute spite and meanness, and there wasn't a thing we could do at that time. So I just wanted to see if this would still catch that type of scenario.
And if I could, just, and to your point, I mean, this is meant to be an expansion, not a limitation, so I think it's going to cover some of those instances.
Good, thank you.
And I've got here in dashboard, so Section 1A, and I'm happy to go to legal services as well, but it says a person commits unlawful exposure who, with the intent to cause emotional distress, distributes an image of the intimate part or parts of another identifiable person, or an image of an identifiable person engaged in sexually explicit conduct. So it seems to encompass both a nude photograph and then also a photograph that shows people engaged in sexual conduct. Was that your question? I just didn't. Okay. Leader Lamberth, you recognize?
Yes, sir, Mr. Chairman, it is. And I just want to make sure that this amendment does not rewrite inadvertently anything that was in there, because, again, the sponsor has clearly said it is to be an expansion from that bill. And I just, in respect to those two young people that sat in my office, I promised them then if there was ever an opportunity to do something about this type of behavior that we would. And so I really appreciate you bringing this. I just want to double check and make sure there is nothing in here that is contracting this. Okay. Thank you, Mr. Chairman.
Okay. Representative Griffey, you recognize?
Thank you very much, Mr. Chairman. And to sort of dovetail in with some of those comments, I'm kind of wondering whether the committee might want to consider, and I'm certainly in favor of this legislation and trying to improve it, but I kind of wonder, the provision that says an image was photographic sexually explicit conduct or whatever, and the person depicted in the image suffers emotional distress. To me, I'm trying to put on my prosecutor's cap now, the assistant DA looking at this case and seeing what's going on, the victim in this, whether it's a female or whoever, they can have the defense attorneys come out and attack them and argue with this. I kind of wonder whether maybe we might be smarter if we alter that language to say the image was photographed or recorded under circumstances where the parties agreed or understood that the image would remain private and a reasonable person would find the distribution constituted an unintended violation of a person's privacy rights. To me, that's a lower threshold, and what we're trying to get at is somebody that's engaging in revenge porn to try to hurt the other party. Because proving whether somebody suffers emotional distress, that's you're requiring the prosecutor to jump over hoops. And I'd love for my leader Lambert to jump in on this. I know he's been prosecuting a bunch of cases too. So anyway, I just throw that out there for consideration.
Yeah.
And I do think the section you just read is actually current law. So if we change that, I think we would be curtailing current law. But it's not a bad. I understand your logic. Leader Lambert, your name was called. If you would like to respond.
Thank you, Mr. Chairman. And to Representative Griffey's point, if there were to be any change there, just in my humble opinion, and this is a question better for legal or for the sponsor, it would probably, what I would say, either that the person depicted in the image suffers emotional distress, or a reasonable person in that circumstance would have. I mean, so that I think we have some other sections in the statute that deal with, and I hate to be, that guy that's got a story for everything, but I tried a case one time where a gentleman was sitting on his front porch and a guy drove by and fired, 8 or 10 shots at him. And he came to court and testified, and I asked the question that you should never ask, well, sir, did this frighten you? And he's looking right at the defendant, and he said, absolutely not, didn't bother me a bit. He didn't scare me. And I backed up and I said, no, look, you got shot at, 8 or 10 times. Surely, sir. Nope, it didn't frighten me a bit. I'm perfectly fine. He don't bother me. And I backed up and realized that was not going anywhere, and the judge kind of took into account that a reasonable person would have been frightened in that circumstance, and we moved on. But to that point, though, it really is, having to prove that you suffered emotional distress, it's a high bar, but I don't know if that's somewhere the sponsor wants to go with this particular bill. It may be a bill for another time.
Yeah. If I could, and actually this question was asked, Leader Lambert on the floor, I guess when the bill went through in 2016, you addressed that. I'm just trying to focus on these two aspects. I do think that's a worthy thing. I've kind of run this through the traps, and everybody's okay with it. I'd hate to throw something here last minute that jeopardizes it. It seems like we have a common interest in this. I'm happy to keep working on this future years, but I'd prefer just to keep this narrow and focused to these two issues.
Very good. Members, seeing nobody else on our list, we're ready to vote. All those in favor of sending House Bill 2789 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules.
Thanks, Mr. Chairman, members.
Thank you, sir. That brings us to item number 5, House Bill 1248 by Representative Thompson. Second. Sir, you have a motion and a second. I see an amendment coded,
there's 2. I just rang 1.
So I want to remind everybody of our posture here. We adopted amendment coded 16270 last week. It's already on the bill. Mr. Sponsor, you have filed 2 amendments that are substantively different. One is coded 16527 and one is coded 16528. Which one would you like to move forward with?
Mr. 27.
Okay. The sponsor moves amendment coded 16527. Do we have a second? Sorry, we have a motion and a second. Sir, please explain your amendment.
Okay, the amendment, last week I introduced this bill, and it was question was about the definition of a law enforcement vehicle, and we simply changed that to marked law enforcement vehicle to which is in other places in the code, I believe, to distinguish it from just the general description of a law enforcement vehicle.
Members, you've heard the explanation. He's referring to B3, which is the property was obtained from a marked law enforcement vehicle as defined in 5510-308. memory serves, last week when we had this debate, we wanted to make sure that we didn't draw in off-duty officers and their private vehicles or other such things. We just wanted to be clear about exactly what we're talking about. So any questions for the sponsor? Seeing none, we're ready to vote. All those in favor of attaching amendment coded 16527 to House Bill 1248, please signify by saying aye. Those opposed, you adopt. Members, you've heard a description of the bill as amended. Any further questions for the sponsor? Seeing none, we're ready to vote. All those in favor of sending House Bill 1248 as amended to Finance, please signify by saying aye. Those opposed, sir, you head to Finance.
Thank you, Chair and Committee.
Thank you. That brings us to item number 6, House Bill 2754 by Representative Harris. Sir, you have a motion and a second. You are recognized.
Thank you, Chairman, and to the committee. So this bill came before our Transportation Committee and our subcommittee as well and made it to the floor. And we had to bring it back to this committee to make a technical change in the language. And so the change was made in the amendment that was made. I don't know if that amendment has already been placed on there, but it's 016286.
So, members, the sponsor has proposed amendment coded 16286. Do I hear a motion on that amendment? And a second? We have a motion and a second. Sir, could you please describe your amendment?
So the amendment makes the change from listing the words Class E felony to re-referring it back to TCA 555116. And so that is the only change. It's already in code. That criminal charge is already in code, and so all it does is re-refer it back there instead of listing it out as a Class E felony.
Thank you, Mr. Chair. I do have our research notes here. I think, just to be clear for the record, I think it does 2 additional things. It clarifies that the temporary tag must be counterfeit or forged to qualify for the felony offense, and it removes the felony offense for temporary plates with a color scheme other than black and white. Does that sound familiar?
So that was a separate amendment from previously. So the original bill was to create a new design with the Department of Revenue. However, the Department of Revenue has already issued out a brand new design in recent months, and so that has a watermarking on there, so it has all the features. This bill simply, all it's saying is that counterfeiting, copying, duplicating a temporary tag is committing a crime, and that crime is under 555116.
Okay, all right. I do have a list that's forming. Chairman Doggett, I have you first. I'll come back to you. Leader Lamberth, you recognized?
All right. So I know you tried to make it match, but with all due respect, the words in your bill do not match the words that are currently in the statute in 555116. So I'm just going to read it just the way it is, okay? It is a Class C felony for any person to alter with fraudulent intent any certificate of title, certificate of registration, registration plate or permit issued by the department or any county clerk of this state by virtues of chapters 1 through 6 of this title. Alter or falsifying with fraudulent intent or forge any assignment upon a certificate of title, or hold or use the document or plate knowing the document or plate to have been altered, falsified, or forged, plate to have been altered, forged, or falsified. You cannot alter a tag. You cannot possess an altered tag. It is an E felony to do so. The wording of your bill says if you counterfeit, copy, duplicate, manufacture, or assist in the counterfeiting, copying, duplicating, or manufacturing temporary plate with intent to defraud. The words, I think the intent, at least to come back to this committee, was to make the words match. Is there any reason why they don't?
Representative Harris?
Okay, so I definitely am going to have to go out and ask legal because we worked on this together on that part. But the wording for this one was simply to affect temporary tags. The current language right now as it sits is not being changed. Nothing is being altered here except for temporary tags related to counterfeiting, copying, duplicating, manufacturing, or assisting in the counterfeiting, copying, duplicating, or manufacturing of a temporary tag. So that is not changing. All of that is still in place. Nothing is being removed or altered. All of this language is still the same as the current one. The current one says Class E felony, and so all this one does is re-refer it back to the 555116.
Leader Lamberth.
If that's your intention, with all due respect, I still don't think you've gotten there because the current statute that makes this a felony if you alter that temporary tag, if you take a black magic marker and alter the date on that tag, you might as well have stamped out a brand new metal tag, okay? Because you have altered the tag. I mean, that may sound harsh, but you cannot do that. I mean, that is something that is, I mean, now, look, that gets handled in the court system all the times. Many times, if that's all someone did, you know, a lot of times it's played down to misdemeanor, dismissed. I mean, stuff happens. But when you see repetitive behavior like that, that's a very serious violation of the law. It's the exact same thing as counterfeiting a tag. But again, the two definitions, for whatever reason, don't match. Was it your intention for them to match?
Representative Harris.
Chairman and Leader, so this bill, I'm may have gotten confused too by what you're saying, because what I am trying to do is simply add temporary tags to this process of being counterfeited and counterfeit, falsified, forged. And so that is being added to this process. That is not altering what our current law is saying already. It is Class E is going to stay a Class E. Nothing in that part is changing. So,
Leader Lamberth.
Thank you, Mr. Chairman. The words alter are in the current statute. They're not in your bill. Do you wish for it to still be illegal for someone to alter a drive-out tag?
Representative Harris.
The current language says a person commits altering, falsifying, or forging plates. So the word is in there. I'm looking at Amendment 016286. And so I did speak with legal, and the words were in there.
Mr. Chairman, if you'll come back to me.
Certainly. Representative Harris, you recognized?
I'll continue until.
Okay. We have no one else on our list, so we were going to take a brief recess.
He's just trying to
brief.
kill it. He's just trying.
We will now go back into session. Members, I appreciate your indulgence. Now that we are back into session, I think we were starting to ask some very pertinent questions, so I wanted to ask them on the record, which was namely, Representative Harris, can you describe to us what problem it is we're trying to solve? You're recognized.
Great. So the initial bill, the very first piece of legislation that this started off as was to have the Department of Revenue create a brand new tag because our current tags were being duplicated, copied, and forged. I got an opportunity to meet with Chairman Howell as well and discuss this as well, but we had tags. If you currently drive around, you'll see some tags that are in black and white. You'll see some tags that have a green line, green stripe going across the top of them. We don't use those anymore, but a lot of people don't know that. And so we have some that you can use a marker with and all that. We don't use those anymore. The only tags that we use at this very second from the Department of Revenue when it comes to temporary tags is a printed form that gets printed through a system. You can print it off from Carvana, from car lots, from anywhere, and a person selling their car from home can print this tag. But it's a tag that has a watermarking on the back of it. I sent someone a picture the other day where the watermarking was not in the photo, and so we were working on the design. Well, the department just created that design, so we want to allow them the opportunity to go ahead and let that design work through its process for just a little bit. But while doing so, the current language, we also have tags that say that people will put on the back of their vehicle that says tag applied for. I know you all seen them that just say the words tag applied for as if they applied for tags. Those are being copied and duplicated. And if you go onto Facebook at this very second while I'm talking to you and just type in tags, $25, they will pull up and they're on sale for $25, and you can drive to Brentwood, Tennessee and pick up 3 or 4 of them if you would like to. So that's what we are trying to fix in this language, is making sure that it is correctly illegal for you to use those parts of the tag. The current language, as it was explained to me by the attorney the first time when I did this, was that it did not have temporary tags listed. Although we would assume and think that license plates cover all types of license plates, it didn't have temporary tags. So I also added that part in there. I didn't change any of the criminal charges on there. Initially, I thought it was just a misdemeanor, but I changed all that in the First Amendment that went through transportation. And so that amendment now says Class E felony. Class E felony is what the current criminal charge is for it. And so we re-referred it to 555116 as requested. So,
thank you, Representative Harris, for that explanation. We have the very good fortune of having the Chairman of Transportation on our committee. So I would like to recognize Chairman Howell, not to put you on the spot, but what say you about the described problem?
Thank you, Mr. Chairman. This bill did come through sub, and it had some issues, and we worked with the sponsor, worked with legal to try to craft it into a position where we could get it out of committee. Once the committee passed it, we discovered, in working with legal again, that the department, and talking to the department, they had been working on a redesign of the tags for several months. And so that issue with the bill was taken care of. They're already redesigning it. Then as far as the issue of making it illegal, discussing with legal, we discovered that the word that's already in the code, which refers to plates, the legal's definition was that did encompass temporary tags. So with that regard, after it passed full committee, I believe that was the reason it was re-referred once it got to calendar and rules, because we felt like it needed another look. And with the current code as it was explained a while ago, I believe that it's already covered under code.
So thank you, Chairman Howell, for that. So I want to make sure you think the problem that we're trying to address here is already illegal.
Yes, simply yes. The problem, as I believe I mentioned this to the sponsor at one point, the problem is not that we need more laws, we need more enforcement.
Okay. I have a list forming. First on my list, I have Representative Griffey. You're recognized.
Thank you, Mr. Chairman. My question is, will this amendment or this current law allow law enforcement to go down to Williamson County and arrest the person that's selling these tags as legal tags?
Representative Harris, you're recognized.
If this one passes and once it's signed by the governor, it would allow that person to go down and arrest that person, yes. It currently allows them to for license plate. Again, the definition that was given to me from legal was that our current license plates don't cover temporary tags. The wording wasn't in there. And so it is, of course, being said now that it is in there.
Representative Griffey.
So my question to perhaps legal is, does current Tennessee law allow law enforcement to go down and arrest someone that is holding out and selling plates that are held out to be legal for temporary vehicle registration purposes?
So I want to thank you, Representative Griffey. I think the question to legal is, does current law allow law enforcement? Say again? Okay. Sure. Chairman Howell, you recognize.
Thank you, Mr. Speaker. I just recalled I have a letter on my desk, a lengthy letter that came in yesterday from a constituent who is very upset because he now has a felony on his record because he took a magic marker and marked out the date on a temporary tag, changed the date. He got caught, got arrested, got charged with a felony, and he now has a felony on him. So I think the answer to that question is there's some law enforcement somewhere in Tennessee that believes that's already illegal to do that. But I will defer to legal.
All right, members, we will go out of session. We're out of session now to hear from Ms. Fogarty. You're recognized.
Michelle Fogarty, Legal Services. It is a Class E felony for any person to alter with fraudulent intent any certificate of title, certificate of registration, or registration plate or permit issued by the department or any county clerk of this state. It is also a Class E felony to alter or falsify with fraudulent intent or forge any assignment upon a certificate of title, or hold or use the document or plate knowing that it has been altered, forged, or falsified. So my answer would be yes.
Representative Griffey, a question for legal?
Yes, to me that sounds like for anyone that alters it or changes something, that doesn't, I don't know that that definition encompasses someone that sells a temporary tag that purports to be legal for purposes of registration with the state of Tennessee.
So the distinction there being, I just want to make sure, you're not altering an otherwise legal document, you're just creating a fake one out of whole cloth.
Exactly.
And you're wondering if that is encompassed.
If the current statute covers that.
Okay. Ms. Fogarty, our favorite game is to quiz you on the spot. Do you need me to restate the question?
I would say that that is encompassed in subdivision 3, holding or using a document that has been forged. It says altered, forged, or falsified.
An interesting quandary. Chairman Holsey, you're recognized.
Thank you, Chairman. If we don't need, excuse me, any law written on what we already have with forgery, but the sponsor of the bill was trying to get revenue to come up with another temporary tag that would make it harder for somebody to forge or more difficult. That was the intent, I believe, at the very beginning. Did you say that we've already got that in the works too? They are coming up with another bill. Okay, that was my question. No, I mean, another tag, another temporary tag.
Thank you. Thank you, Chairman Holsey. I have a question for legal, since we're out of session. Can you read for us the definition of forgery? She has a special computer that has it on there. Yeah.
Michelle Fogarty, Legal Services. Forgery, a person commits an offense who forges a writing with intent to defraud or harm another. Forge means to alter, make, complete, execute, or authenticate any writing so that it purports to be the act of another who did not authorize the act, have been executed at a time or place or in a numbered sequence other than what was in fact the case, or be a copy of an original when no such original existed.
Thank you for reading that definition. So 555116 says it is a Class E felony for any person to, 1, alter with fraudulent intent any certificate of title, certificate of registration, registration plate, or permit issued by the department or any county clerk of this state by virtue of chapters 1 through 6 of this title. Then we have 2, alter or falsify with fraudulent intent or forge any assignment upon a certificate of title. So the word forge there is only referring to the assignment upon a certificate of title. It's not talking about creating something new out of whole cloth. And 3 says hold or use the document or plate, knowing the document or plate to have been altered, forged, or falsified. So the act of forging it does not seem to be encompassed in that, but I'm just a caveman lawyer. Leader Lamberth, you're recognized.
Mr. Chairman, are we out of session with legal, or are we back in session?
We are out of session. We're out of the matrix.
All right, outstanding. I want to commend the sponsor, one, for standing there respectfully while we all did what we do best in the Criminal Justice Committee, which is debate this stuff and genuinely try to figure out, look, you want to make sure this stuff's illegal. We want to make sure this stuff's illegal. Nobody needs to, like, copying or falsifying. I would, either back in session or now, Mr. Chairman, I would make a humble recommendation, potentially roll this a week. I know you've been through the ringer on this bill, but both off mic and on mic, I mean, you've said what you want is for this stuff to be illegal, that you can't copy, you can't forge, you can't, do any of this stuff. That I think there's a way to get there. That's just my opinion. There's a part of me that thinks we probably don't need this bill at all. I mean, you started out saying, hey, y'all need to make a new temporary tag. That's accomplished. Well done, by the way. I mean, I think that's great. Working with the department, working with the chairman of transportation, you seem to have accomplished that goal. The rest of this seems like it's more a conversation on to just make sure the wording's there to ensure no one could be copying off tag applied for, which, by the way, maybe next week we can hear from somebody from safety or revenue or somewhere else. I'm not even sure, and this maybe is a question for a patrol officer. I'm not even sure the tag applied for gets you off the hook. I think you actually have to have a tag on the back. You can have tag applied for all day long, and maybe it gets you a little grace from some officers, but I think the law says that you have to actually have either that drive-out tag or a plate. Just saying, hey, I'm trying to get a tag, I'm not sure gets you off the hook criminally. So, I don't know, Mr. Chairman, I think there's quite a few questions left on this one. I commend the sponsor for continuing to work through this process, but I'm just not sure we're there yet.
Representative Hardaway, just a reminder, we're still out of session. Do you have a question for legal, or we can go back in session if you want to speak on the bill? And I promise to give you as much time as you like either way.
Yeah, I'll wait.
Okay. Seeing no more questions for legal, we are back in session. We're back on the bill as amended. Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. And I think we've already had several members acknowledge that the member has been able to accomplish part of his bill, the intent of his initial bill. I would suggest that the evidence that we need some clarity in the law is this what we're doing now. So I would certainly hope that the members would support the bill merely, if not on substance, changing substance, the fact that the way the law is styled, there's not the clarity to where Jane or John Doe can pick up a book, open it to this, and understand what they can and cannot do. If the learned lawyers who sit on this committee have back and forth on it, and we come to no conclusion, it's obvious that we need some clarifying language to make this statute more clear and to did I say that? To make this statute clearer and to enable just a typical layman to pick up the book and say, this is what I can do, this is what I can't do, and here are the consequences. So I'm going to agree with Leader Lambert that we take some time, work on language, but I would like for that to be kept in mind, that even If it's a question about whether the substance is covered in current statute, I don't think there's any question that it ain't clear. And we need this bill to make it clear. Thank you, Mr. Chairman. Thank you, sponsor.
Thank you, Representative Hardaway. Next on my list, I have Representative Chairman Doggett. You recognize.
Thank you, Mr. Chairman. And temporary tags are state governmental issue tags. 3916-504, destruction and or of tampering with government records. You just pulled it up. Okay, that was going to be my question. I think that the forging or falsification of temporary tags would fall, I would think, underneath this statute right here.
Chairman Doggett, I think that sounds right. Good old-fashioned forgery probably would cover it.
Yes, sir.
So for that question, we're going to go out of session to hear from the amazing and talented Michelle Fogarty. We're out of session.
Michelle Fogarty, Legal Services. 3916-504 is destruction of and tampering with government records. It is unlawful for any person to knowingly make a false entry in or false alteration of a government record, make, present, or use any record, document, or thing with knowledge of its falsity and with intent that it will be taken as a genuine government record, or intentionally and unlawfully destroy, conceal, remove, or otherwise impair the verity, legibility, or availability of a government record. Class E felony.
To restate that, forgery of a government document is a Class E felony. All right, we're going back in session. Representative Harris.
All right. Thank you, Chairman. And thank you to the committee for entertaining all of this. And I know I serve at the pleasure of the leader, so I'm going to roll it 1 week.
Without objection, we will roll 1 week. Members, that brings us to item number 7, which is House Bill 2147 by Chairman Moody. You have a motion and a second, ma'am. I also see an amendment coded 16005.
Motion amendment.
You have a motion and a second. And
Question on the amendment.
question has been called on the amendment. All those in favor of attaching amendment coded 16005 to House Bill 2147, please signify by saying aye. Aye. Those opposed, you adopt. We're now on the bill as amended. Chair Lady Moody, you recognize.
Thank you, Mr. Chairman and committee. For those that weren't in sub, we on the Human Trafficking Task Force, there's an international group called Shared Hope, and they monitor what states are doing with their human trafficking laws. So it's kind of like if you get to be number one with Shared Hope, that's the gold standard. So we have been number one several years in the past. And so Shared Hope has changed their rubric for how you get to be number one. So this is a very comprehensive bill. It covers several sections, but we are updating, correcting, and making clearer a lot of our human trafficking laws that apply to victims that are 18 or younger. And so let me see if I can do a little bit better, Bill. It standardizes assessment and screening processes for youth-serving agencies. It creates a more victim-centered response to these instances. It's similar to what we have done in the past for minor victims of prostitution and strengthens the law with regard to prosecution of these offenses. I can certainly take a deeper dive if you want, but that was the goal, is to get these things in line so we can be number one in the country again.
Chair Lady Moody, thank you so much. Very worthwhile effort. Appreciate your work on that, and I think I speak to the rest of the committee when I thank you for your work on that. If there's no questions for the sponsor, we're ready to vote. All those in favor of sending House Bill 2147 as amended to Finance, please signify by saying aye. Aye. Those opposed? Ma'am, you head to Finance.
Thank you. And, of course, I had lots of help as Governor's Office, Valerie there, and Leader Lamberth, and so many other people. And, of course, I always want to give credit in memory of Representative Jim Coley and all his
Amen.
work. He laid the groundwork for us. So
Amen.
thank you.
Thank you, Chair Lady Moody. Leader Lamberth, you recognized?
Thank you, Mr. Chairman. My name was called. I really want to say I have done very little to help Representative Moody with this bill other than for Leader Gant and I to discuss the fact that it should be assigned to her, because when she carries a bill, I find that most of us trust her explicitly, and especially in this area. And like Representative Coley, who may be looking down from above, she's taken the torch and really ran with it. And quite frankly, I know that when you're running a bill, it's a good, solid bill, and I have a tendency to just vote for it.
Amen. Members, there's no other business before this committee. We are adjourned.